second part of the lecture, today's lecture, and I was to discuss stay of execution. Yes, stay can be granted in case there is execution petition, but question is which court can grant stay. Normally, it is the appellate court. That court may grant stay for execution of the petition. But if there is no appeal, can such stay be granted? And if so, by which court? Yes, it can be granted. It can be granted by the transferee court. And it is interim stay. And that too to seek clarification from the court which passed the judgment and decree. And in case a part of the judgment decree has been satisfied by the judgment debtor, to get the amount adjusted and get the judgment and decree amended, and it is to be within the period given by the transferee court. Otherwise, transferee court cannot stay the execution of the judgment and decree. In case liability of judgment debtor is discharged and it is discharged during the pendency of the execution petition, the execution petition can be disposed of by the court before which it is pending on the basis of such discharge, with confirmation of such discharge by the decree holder, and after that the judgment debtor will be absolved of execution proceedings. Next topic is mode of execution. Mode of execution, there are two modes. One is against person, execution of judgment decree against the judgment debtor by adopting any of the two modes, which is number one, against person, that is by the arrest of the judgment debtor or by attachment and sale of the immovable property or the property. So these are two modes which are normally adopted for the execution of judgment and decree. If there is a decree for specific immovable property, that specific immovable property is to be recovered, attached after the execution petition, and for that process is issued, and judgment debtor is to obey the order passed during the execution petition. If he denies or if he creates any hindrance, the court has ample power to deal with that. And in case of decree for specific performance, for restitution of conjugal rights or for an injunction, specific performance I explained already. But in case where there is a suit for restitution of conjugal rights and it is passed against the wife and the wife fails to comply with the judgment and decree, the court can pass an order for attachment of the property owned by the wife. But in case if such judgment and decree is against husband, the court may direct the husband to pay periodical amounts in court to the wife. In case he does not comply, a decree passed against him in a suit for restitution of conjugal rights. So both are to accordingly comply with the provisions with the requirements of the order. Similarly, there are decrees for execution of documents or endorsement of negotiable instruments. They are to be dealt with by the orders passed by the court in execution proceedings, and they are to be satisfied accordingly. Where the property is immovable property and it is in the possession of tenant. The property is in possession of tenant and the property is of judgment debtor. The court will direct the tenant to hand over the possession of the property to the decree holder, or the court may attach the rent and ask the tenant to thenceforth make the payment of the rent to the decree holder. These are some of the eventualities of execution of judgment and decrees, in each case having different reliefs claimed and granted. In case there is order of the court about the arrest of the judgment debtor, what will be the fate of the judgment debtor? The court has discretionary powers to permit judgment debtor to show cause against detention in prison. Show cause why he should not be detained, and if the judgment debtor satisfies the court may not proceed with the detention and court may not arrest. But if it decides otherwise, then the warrant for arrest to direct judgment debtor, they are to be issued by the court. In such arrest, the judgment debtor is not handed over to camp jail or jail authorities. He is committed in civil prison, and all the expenses of the civil prison are to be met by the decree holder. The order and the rules mostly deal with the situations where there are relief of different natures, whether the relief is about movable property, whether the relief is about immovable property and the attachment of such properties, and I have already discussed the mode of execution of decrees against judgment and decrees in such cases, and that I discussed in my previous lecture, not in this lecture but previous lecture at length. So I am not going to repeat that or revise that. I will only revise in order to conclude. Mode of execution, two kinds of modes: arrest of judgment debtor or attachment of the properties. Properties here include both movable and immovable according to the nature of the relief claimed, the courts to which application lies, the courts which can execute judgment and decrees, the court which pass the judgment and decree. But here I will make another aspect clear. Let's suppose a suit for specific performance was filed before the civil court, trial court. Suit was dismissed. Appeal filed. Appeal was also dismissed. Revision filed. Revision. High Court set aside the judgment and decree of the appellate court and the trial court. Now, in revision, a judgment and decree has been passed by the High Court. That judgment and decree is got to be executed. Question is, which is the court which can execute such judgment and decree? The High Court will send the file for execution of such judgment and decree before the civil court which originally heard the case, dismissed the suit, and the civil court will execute the judgment and decree passed by the High Court as if it has been passed by it. Similarly, if the parties go up to litigation to Supreme Court, the apex court, and the apex court reverses the judgment and decrees and orders of the all lower courts, subordinate courts, and eventually the case is decided in favor of the plaintiff, Supreme Court will not execute the judgment and decree. The Supreme Court, again like High Court as I just explained, will send the file to the trial court, not the same judge which dismissed the suit, for execution of the judgment and decree passed by the Supreme Court. In other words, if the Supreme Court does not send the file, the party in favor of whom there is judgment and decree passed by Supreme Court, that party will have to file application before the civil court of original jurisdiction with certified copy of judgment and decree passed by Supreme Court. And the civil court will be the executing court. It takes ages from civil court to Supreme Court. If the civil court is still there, not judge, civil court is still there, the decree holder is lucky. But still, he is not unlucky if the civil court or the court which initially dismissed the case or the suit, that is abolished, that is no longer in existence, then where will the execution petition lie? The execution petition will lie before another court which is or which will be competent to adjudicate upon case of similar nature and decide the case. A is the court which was established, which was abolished, and it dismissed the suit for specific performance of the contract. When the Supreme Court passed the judgment and decree, Court A is no more there. But Court B is there, which is deciding such cases. The application will lie before Court B, as if Court B has passed that judgment and decree, or Court B was competent to pass that judgment and decree, or it was Court B which dismissed the suit for specific performance of the contract initially. So these are the instances. It does happen. Parties go up to the Supreme Court, and from Supreme Court they are back, but they are back with fruit, not without fruit, and fruit for the party in favor of whom there is a judgment and decree. We have discussed all these modes. We are at last leg of the Order 21, which deals with what if any of the party, what if the judgment debtor resists the execution of the judgment and decree. If the judgment and decree is resisted, the execution of it is resisted by the judgment debtor, the court has ample powers to punish the judgment debtor. Apart from he has a judgment decree against him, and above all, he will have to face a punishment, and that may lead to his imprisonment, apart from the execution, the attachment of the property, whether movable or immovable, against which he resisted. He may himself resist it, or may depute his servants or any other person to resist the execution. Ultimate responsibility will be of the judgment debtor, along a person who resists the judgment execution of such judgment and decree. Execution of judgment and decree, if resisted by the judgment debtor or any person on behalf of judgment debtor, in that eventuality the court has power to punish such judgment and decree. With this, I conclude Order 21. Next is Order 22. I will today give you intro, and will discuss it at length in my next lecture. It is about death, marriage and insolvency of parties. Suit is pending, appellant dies. Suit is pending, defendant dies. What is the fate? Suit is pending, there are more than one plaintiffs. Suit is pending. First eventuality is there is a plaintiff and a defendant. Sole plaintiff, sole defendant. If the plaintiff dies, what will be the fate of suit? If the defendant dies, what can be the fate of the suit? If there are more than one plaintiff, one of them dies, can court proceed with the suit? If there are more than one defendants, any one of them dies, can court proceed with the suit? Or the suit will abate? We will see to it. Marriage of female has any effect on a suit pending in court? Let's see. And if the plaintiff is insolvent, becomes insolvent, bankrupt, what will be the fate of a suit filed by such plaintiff? He becomes insolvent, makes no difference. But if he is adjudged insolvent, when the word adjudged is used, it means declared by a court of competent jurisdiction that such and such person is insolvent, has become insolvent, bankrupt. That insolvency is to be considered while deciding the factor as to continuance of the suit on these grounds, or the suit will abate. Prior to 1972, in 1972, certain amendments were brought in this order, and prior to 1972, the position was different. After 1972, it's other way around. So this Order 22 deals with death, insolvency and marriage of the parties, and it is from Rule 1 to Rule 12. This order and Order 23 and Order 24, I will inshallah deal these orders in my next lecture. And Order 23 comprises of 4 rules, and it is about withdrawal and adjustment of suits. Can a suit be withdrawn after its institution? Can any adjustment be made after the institution of the suit? These are the questions which have been addressed to by Order 23. And Order 24 is about payments made into court. This is from Rule 1 to Rule 4. Hopefully, I'll be able to deal with these 3 orders in my next lecture. I hope by now it's clear to you what is meant by execution of the judgment and decree and orders, which is the court competent to execute judgment and decree, what are the modes of execution of judgment and decree. When I started this order, I told you that nothing to worry, though it is lengthy, but it is very simple. See you in next lecture. Thank you very much. God bless you.